Hey guys, this is Vijay Dinakar. Today I want to talk about 10 DUI defenses in California. So DUI, or driving under the influence of alcohol, is defined by two California Vehicle Code sections, 23152A and 23152B. So 23152A is driving under the influence of alcohol. So that basically means that you're not safe to operate a motor vehicle given the level of your intoxication. And that's regardless of what your blood alcohol level is. The other section, 23152B, is a per se alcohol by volume law. So if your blood alcohol is 0.08 or higher, then you've violated that statute. So the number one defense that we can talk about for both of those two violations is basically that the stop the officer made when you're driving your vehicle was illegal. So if you're driving your car and the officer believes that you've committed a violation of the law by speeding or by going through a red light or making an illegal turn, and there's enough evidence, meaning more evidence than not, or probable cause that you've committed a violation of a vehicle code section, he's allowed to pull you over. And that's typically how a DUI investigation starts. Someone commits a vehicle code law violation and the officer turns on his sirens and begins to pull you over. He comes to your car and he says, "I smell alcohol on you," or "How much have you been drinking?" And then begins the entire DUI investigation. At some point, you're given either a breath or blood test, and those results come back, and then you're arrested. However, if the officer didn't actually have probable cause at the time of pulling you over, meaning there is not enough evidence that you were speeding, that you went through a red light, that you made an illegal turn, or any other law violation, then all of the rest of the evidence that the officer collected after making that stop is suppressed or thrown out. And so that's a total defense, regardless of whether the allegation is that you were under the influence of alcohol or that your blood alcohol level was 0.08 or over, because the entirety of the case or the evidence is thrown out after the illegal stop was made. So that is the best kind of defense, and that's why I'm talking about it first. The second kind of DUI defense in California is driving pattern evidence, allegedly proving that you're under the influence of alcohol. So the officer will often write in his police report that the person's driving pattern, so weaving inside and outside of the lane, or speeding up too fast or slowing down too slowly, or driving in a jagged manner, indicates or proves that the person was under the influence of alcohol at the time. The problem with this is that this is basically based on entirely bogus science. There really is no DUI or under the influence driving pattern, and the driving pattern can easily be explained by many other reasons beyond being under the influence of alcohol. The third DUI defense in California is that the field sobriety test, or FSTs, are extremely unreliable. So the field sobriety test, as you might have seen in a movie, is the officer, after pulling you over, tells you to walk in a straight line, or stand on one foot, or count the alphabet, or the I-nystagmus test, or any number of different field sobriety tests. Now, these are basically not based in science. They're not based on objective measures. And often, even when there are published manuals, for instance, the California Highway Patrol manual about how to perform these field sobrieties, these officers do not actually follow the procedures and manuals that are published. So you often definitely want to fight the claim of being under the influence of alcohol. Again, the 23152A count, based on the field sobriety tests. Because that's one of the only ways that they're going to be able to prove that A count is the officer's going to claim that he made you do field sobriety tests and that you failed, and here's why you failed, and here's how you failed. The problem is that these tests are inherently unreliable, and that the officers, even when there are published standards for how to perform these tests, they don't actually follow those standards. The fourth DUI defense is related to the field sobriety test, and that is generally just objective symptoms of intoxication. And that phrase is often seen in a police report in a DUI case. In order for the officer to prove the 23152A count, he says, I observed objective symptoms of intoxication. What are those? Slurred speech, unable to walk in a straight line, unsteady gait, unable to follow directions, unable to understand time, being confused. These are all in the officer's police report, and if it went to trial, the officer would testify that the person arrested for DUI was basically demonstrating these objective symptoms of intoxication. The problem with these, like with the FSTs, are that these are really not based on any science. Number one. Number two, there's no baseline for comparison. So the officer, in claiming that you had slurred speech, can't know if you had actually slurred speech unless he had a voice exemplar or knew what you sounded like before he was listening to you talk during this DUI investigation. He can't know if you're walking in an unsteady gait for you unless he's observed you walking previous to this DUI investigation. So he can't know if you're not able to understand directions because of your objective symptoms of intoxication, or simply you're nervous because it's a DUI stop, or you're just generally not able to follow instructions. So again, that's a good DUI defense. The fifth DUI defense is if you're a diabetic patient, this can actually affect your objective symptoms of intoxication as well as a breathalyzer machine. So if you're a diabetic and you have a blood glucose level of 250 milligrams per deciliter or higher, you can actually enter a state of what is called ketoacidosis, which is a dangerous medical condition which can actually cause objective symptoms of intoxication. So you can feel and be seen as being confused, unable to follow directions. You can actually have a flushed face, and you can have increased thirst. Those are all symptoms of objective intoxication, as well as what you would actually see if you were entering a state of ketoacidosis, if you're a diabetic patient. Additionally, if you're entering a state of ketoacidosis, you're going to produce ketone bodies. And ketone bodies will first of all show up as acetone, which is a ketone body that will actually affect your breath. So the officer might think that he smells ethanol, which is alcohol. Actually, there is no smell of ethanol. What the officer will actually be smelling are what are called congeners. Those are in all kinds of alcoholic beverages. But anyways, the acetone smell will often smell like these congeners. So that's number one. Number two, the acetone will potentially be picked up in some breathalyzer machines, as well as other ketone bodies, indicating a higher breathalyzer readout because of these ketone bodies that are produced through ketoacidosis. So diabetes, if you are a diabetic patient, can both affect the 23152A, which is under the influence of alcohol, as well as the 0.08 if you take a breathalyzer machine. The sixth DUI defense is related to what we just talked about, and that is if you're on a ketogenic diet, you yourself will produce ketone bodies, including acetone. So you may have an acetone breath, number one. Number two, you may have a different reading on the breathalyzer because of the production of ketone bodies. And that actually can be increased when you consume alcohol. So if you're in a state of ketosis, which is a very popular diet nowadays, you will produce acetone, you will produce ketones. When you consume alcohol, that absolutely can affect the breathalyzer test. Now, you will not be in a state of ketoacidosis, which is a dangerous medical condition. In fact, if anything, your mental state will be increased, so you will not, or you should not, actually have objective symptoms of intoxication, unlike the diabetic patient, but you will produce acetone and ketone bodies, which in fact can affect the breathalyzer test. Seventh DUI defense in California is the notion of mouth alcohol. So if you have recently gargled with Listerine, or you've even been chewing gum, and at that time or after that, you had consumed alcohol, actually the gum will keep in it alcohol remnants. Additionally, if you've consumed food, which may contain small amounts of alcohol, that itself can have alcohol in the mouth, which can affect the breathalyzer. The breathalyzer is not designed to detect alcohol within the mouth or the oral cavity. It's detected the actual breath or in the lung. So if you still have remnants of alcohol in your mouth, that is certainly going to affect the breath test. And that can happen quite often, even if you're burping before the performance of the breathalyzer, that can take alcohol contents and put them closer to the mouth, which it can affect the breathalyzer. So you have to look to see in the police report if the police officer has carefully observed you for at least 15 minutes before you actually do the breathalyzer, to make sure that you're not consuming any fluids, that you're not consuming any food, which can affect that you're not chewing gum, that you're not vomiting, and you're not burping. That can all affect the breathalyzer, which is in fact supposed to be a calibration of your blood alcohol level, not of how much mouth alcohol that you have. The eighth DUI defense is that the instrument, again, the breathalyzer, has not been properly calibrated. So in order for a breathalyzer to work reliably, we need to know that it's producing reliable outcomes and accurate outcomes. And so there is a requirement that the breathalyzer be periodically calibrated using a known sample at a known quantity of alcohol concentration. And if the officer or the police department hasn't properly calibrated that instrument, the results are entirely useless. They're not reliable. And it's for the government, the police department, to prove that they properly calibrated this instrument at regular intervals and that the known sample was of the solution that it claims to be. And oftentimes, police departments are not properly calibrating their breathalyzer. We demand the calibration logs. We see that they're not being calibrated. And then that result that may have been produced with respect to a 0.08 or higher alcohol result is entirely not reliable. The ninth DUI defense is that there is an inherent error rate in all breathalyzer machines. And what that error rate is disagreed with by different experts, but you will hear, even from prosecution experts, that there is anywhere from a 0.005 to a 0.015 error rate in the breathalyzer machine. Now that might not seem like a lot, but when we're dealing with 0.08 and higher illegality, that error rate, inherent error rate, can absolutely affect the outcome of the results, especially if you got a 0.09 or a 0.10. So the error rate itself, and this is something that the prosecution experts are going to agree with, even if it's been properly calibrated, even if the operator of the breathalyzer machine did everything he or she was supposed to do, there is an inherent error rate, which again, if you have a borderline DUI and you got a breathalyzer, that can absolutely be an effective DUI defense. The final DUI defense is what we could call the no drive DUI defense. And this is a very effective DUI defense, just like the suppression defense. If this is understood and accepted as an effective defense, then it doesn't matter what the blood alcohol level measured was, whether by blood or breath. And that is that it's illegal to drink and drive. In other words, you have to have a blood alcohol reading of 0.08 or higher, or be under the influence of alcohol and be driving. However, if they can't prove that you were driving or when you were driving, even if they eventually get a alcohol reading of 0.08 or higher, or they see after the fact that you're under the influence of alcohol, this can be an absolute defense. And often you see these kinds of no drive defense cases emerge when the officer comes to the side of the road where a car is legally parked, and there might be someone sitting either in the passenger seat or the driver's seat, and the car is off, and the officer knocks on the window, and the person comes out of their sleep, and then it begins the DUI investigation. But in the course of that investigation, it is not discovered, first of all, that the person was driving, because the officer did not see the person driving. There's no witnesses to the person driving. And even when the person drove, or that the person, after having driven at some point, didn't stop, park the car, turn off the car, go outside the car and drink after that. Again, it's for the government to prove all of the elements of a DUI offense, not for the person accused of DUI. So I think we've gone through 10 common DUI defenses in California. There are actually many other DUI defenses that I've seen. But if you guys have any other questions about DUI, definitely let me know. Take care and all the best.